Hello, everyone. This is the second episode of the Freedom of Religion or Belief of FoRB podcast that we are making as a part of Talk About Law and Religion blog. I'm Dmytro Vovk, visiting professor at Benjamin Cardozo School of Law, and my co-host is Merilin Kiviorg as associate professor at University of Tartu. Hi, Merilin.
Hello, Dmytro. Hello, everybody.
Last December, the Court of Justice of the European Union ruled that the public administration bodies across the EU can prohibit their employees from bearing visible religious symbols, including obviously Islamic headscarves and crucifixes. The decision came after a Muslim employee working in Belgium filed a lawsuit in 2021 against her municipal employer after being told that she could not wear a headscarf at work. This decision is one among several others that the Luxembourg court delivered on religious freedom at the workplace, maybe during the last 7 years. These decisions provoke some criticism both from religious minorities and religious freedom defenders and academics. In particular, they argue that the court's approach enables restrictions imposed on employees' religious symbols or attire simply because it's good for the business. And it's also very problematic for religious minorities, for example, Muslim or Jewish women who might face a hard choice between following their religion and getting employment opportunities. And this is the topic we'd like to discuss today: religious freedom, employment, and business, trying to combine the religious freedom perspective with maybe less evident for the FoRB community, the perspective of business and human rights. Our guest today is Dr. Matteo Corsalini, who is a postdoctoral researcher at the University of Siena in Italy. Last year, Matteo published an extremely interesting book called Business, Religion, and the Law: Church and Business Autonomy in the Secular Economy. Hello, Matteo.
Hello, Merilin. Hello, Dmytro, and thank you for having me.
Matteo, before we start discussing the topic, could you explain to us what is the economic or business aspect of freedom of religion or belief? Because it's still quite a new approach for lawyers and for defenders, which I would say tend to think religious freedom in more political and legal categories rather than in economic terms.
Yeah, sure. Well, there is actually an economic or business case for religious freedom, which is emerging right now. It is quite interesting. The underlying argument is very simple. The idea is that religious freedom could be understood as an asset in the truest sense of the word, meaning that beyond being a human right per se, new research is considering religion also as a criteria, as a resource for economic value, something that could be measured, analyzed by countries, companies, and that can leverage religion with the expectation to produce sustainable long-term good. Now, interestingly, the word religion, and when it comes to religion and economic freedom, I used and employed the word asset. And I haven't picked this word randomly, but I think that describing religion as an asset resonates coherently with some official European terminology. Just to give you an example, consider the case of the Council of Europe and the ECtHR, the European Court of Human Rights, which is the judicial tribunal of the Council. In its very first religious freedom case, the ECtHR used precisely the word asset to describe religion. So it said, religion is a precious asset that protects faith-based citizens, but it could also stretch as far to include atheists, agnostics, skepticals, those unconcerned more generally.
Here, Matteo obviously mentions the case of Kokkinakis versus Greece, decided by the European Court of Human Rights in 1993. It is considered to be the first case where the issue of freedom of religion or belief were brought before the court.
Now, on that particular case, the court was talking about and considering religion as a human right per se, as a vital source that actually make up the life of individuals and protects their identity and their own particular conception of life. So the European Court of Human Rights generally understands religious freedom as a human right. But as I said, it should not be disregarded that religious freedom could be considered also somehow beyond individuals. And so also considering other aspects of life, considering, for instance, also the environments where individuals operate, reside, and live. And so this is pretty much I think, it lies at the heart of the approach, of an economic approach to religion, an approach that doesn't consider individual per se, but as I said, also the environment. So it brings questions, for instance, concerning which public or private goods, for instance, could be adversely affected by low levels of religious freedom protection. And then in turn and eventually, how could it be that disruption of public or private goods could further exacerbate human rights violation at a very individual level? So for instance, there is research considering how religious conflicts or religious violence could create political instability, and how political instability in turn could disrupt some economic strategic sectors within countries. And so this research considers how, well, investors themselves could think of religious freedom as a proper metrics that they will use in their business decisions. So they will consider degrees and levels of religious freedom protection in their costs benefits analysis. They will not run or invest in companies where political instability, also religious related political instability, could disrupt the normal conduct of the operations. Now, for instance, just to mention a few names, I do remember some research by Brian Grimm, who in 2014 asked the question if religious freedom is good for business. And he tried to answer this question, co-authoring a paper with Glenn Clark and Robert Snyder. And in this paper, they were trying to demonstrate also through some empirical research how religious freedom could be good for economic growth. So considering as a variable in economic growth in 173 countries and their GDP, basically. So they considered religious freedom from this external perspective, so I could put it. So from the perspective of domestic and foreign investments, so how investors could consider religion. But then Brian Grimm also considered the issue, the economic aspects of religion, also from the internal perspective of the company. So considering how religious freedom could, well, affect corporate governance and how it could enter the equation of how to strike a proper balance between business freedoms and human rights.
This is very, very interesting. And we're going to probe into this question of whether this asset, the freedom of religion or belief, which is so important for individuals and forming their identity, is actually protected by the European Court. And in your book, you also compare it somewhat to the US approaches in similar matters. But I wonder also, for sort of general start, how you place this discussion on freedom of religion or belief, FoRB, and business into the context of more broader developments in the field of human rights and business. And business and human rights are also kind of like a developing area in the framework of human rights protection, although I'm focusing, of course, more on the matters such as work conditions and so on, so more basic needs of humans when they work. And not much hard law is created in that field. But I still push you maybe to reflect on how these two kind of discussions fit together.
Well, when it comes to business and human rights, the main challenge is how to strike a balance, how to find a proper equilibrium between the financial and the social performance of companies. And so the question is how freedom of religion of belief could help sorting out this kind of balance. And if we follow in the footsteps of Brian Grimm research, for instance, we could see how he found a positive correlation between heightened religious freedom standards of protection and heightened financial and social performance within within a company. And in support of this contention, he would make a very first core argument. So the idea is that promoting religious freedom in the workplace could bring to more inclusive and diverse workplaces, which means that employers, by allowing their employees to bring their faith at work, will also stimulate a stronger sense of belonging, stronger sense of workplace solidarity, which in turn will positively affect employees' morale and relatedly employees' productivity. So religious freedom is used somehow, again, as a metric, as a tool throughout which employers could somehow, in pretty much an utilitaristic sense, could extract more value in the long term from the employees. Employees will be more happy and basically will deliver more. Another aspect that I found interesting is that beyond allowing employees to bring their faith in the workplace, they would also be able to bring their own identities, their own, perspective and worldviews, which would make employees a valuable resource also to obviate a very tough issue in companies, which is groupthink. So the idea is that there are some conventional rules, majority rules that should be followed, that sometimes could stifle creativity, innovation, and could prevent companies from thinking from the outside of the box. But now, what I'd like to stress is that the research that I have been mentioning so far, so grim research, we generally find that there is a positive correlation between religious freedom and business growth and business sustainability. But correlation is not causation. So this is, I think, an important thing to stress, which means that this research explained that religious freedom positively correlates with business sustainability, but it's not able to demonstrate if religious freedom is the sole and unique cause that direct could stimulate much more innovation. Because the point is, when it comes to sustainability, there are several factors that should be taken into account. So religious freedom could be seen as a variable that could work in tandem with other variables. And I think that this becomes quite clear if we look at now very, very popular discourses on so-called ESG, which is a somehow new business approach to business and investment, which says that companies should take into account some environmental, social, and governance standards. And all these standards should somehow work in tandem. So briefly, what does it mean? Companies are expected to demonstrate, for example, how they deal issues concerning the environment and how they could remove some kind of externalities, negative externalities that could create and could damage the environment. This would be the E of ESG. Then you will have the S, how companies should report on how they deal with employees, the management of the workforce. And then you will have the G, which concern more internal aspects, such as shareholder rights, accountability, leadership, the board of directors, how it is composed, gender diversity in the board, and several things. So we have several things on the plate that should be considered. So if we, with this in mind, for instance, we could consider how religion could positively benefit the S, the social aspect of ESG. This according to Grimm previous research. So the correlation between religious freedom and better workplace conditions. So as I said, religious freedom could strengthen workplace solidarity, but just to be slightly provocative, what if sometimes things can go even the other way around? What if accommodation of religious freedom in the workplace could diminish workplace solidarity? I think they should be taken into account. For instance, consider the case of employees who do not want to work on a particular day of the week. Recently in the United States, the United States Supreme Court said that employers must accommodate this kind of requests. And by saying so, what the literature is considering despite this being a very general positive development, the literature considered how by accommodating religious employees, employers would be required to reschedule their program, to reprogram their work shifts and everything, and how the costs of accommodating a religious employee could be shifted onto other employees and therefore create animosity. Sometimes another employee could be required to take word unexpectedly due to the conscientious objection of another one. So this is just to say that, yes, generally we could say there are positive correlations between religious freedom and workplace well-being, but we are talking about correlations, not causation in itself. And this correlation should be taken into account on a broader case-by-case basis.
You mentioned that employees can bring their religious identities to the workplace, but it seems to me that the case law of the Luxembourg court is developing in a sort of the opposite way. The court seems to be gradually expanding the discretion of employers in regulating religion in the workplace, including their power to completely ban all religious symbols.
Yeah, indeed. We had a new decision. We had a recent new decision in November, which still seems to confirm this trend. But the particular and interesting thing is that this case concerns and deals with the perspective within public workplaces, not private. So now, just to recap briefly, to begin since the beginning, to see how we came to this point, I think we should come back to 2017. In 2017, the very first issue on religious freedom in the workplace was delivered by the Court of Justice. It was something completely new, and this was the so-called first episode of what I would call the Aspita saga. So a series of episodes concerning religious freedom in the workplace. In this very first case, the matter at hand concerned the dismissal of a Muslim employee from the work sphere by some employers who want to keep a neutral image. And the case was brought to the court, and the court was asked to settle two particular questions: whether a policy of neutrality within the rules of the company amounted to direct or indirect discrimination. Now, the direct discrimination issue was dealt more specifically by the court in a sister case that was issued on the same year, which was called Micropole versus Buñuel. And on that case, the court said that a company, including a policy of neutrality within its rules, does not directly discriminate, because this policy of neutrality equally applies to all employees and was generally intended to prevent not just signs of religious expressions, but any kind of ideological signs in the work sphere. So since the policy was related and extended to all ideological in the workplace, be they religious or not, this case could not amount to direct discrimination. So there was no enough sufficient evidence to prove that this policy of neutrality was directly aimed at singling out Muslim employees and dismissing them in particular. But then the question was whether this company, however, could bring a case of indirect discrimination. And well, the court generally said yes, that at a very general level, a policy of neutrality could indirectly discriminate. But then the interesting thing is that the court went beyond somehow the questions that were asked to give some guidelines to domestic courts on how to understand whether a policy could amount to indirect discrimination. And so in doing so, the court focused exclusively on the business side of the equation. So it said that this policy could indirectly discriminate, but it will not be indirectly discriminatory if some further requirements are introduced. for instance, if the policy is applied systematically, meaning that it covers effectively all religious but generally ideological symbols of expression, if it applies in an indifferential way, meaning that it applies to all employees, and then but all employees with a customer-facing role. So the court gave some instructions basically on the cases in which indirect discrimination does not occur in the face of a policy. But in doing so, it did not take into account at all the religious freedom side, the religious freedom rights of the employees that were involved in that particular case. And this approach was repeated in some further instances. So we have the sister cases, 2017, Ashbita and Bunyawi, and then the same elements was brought and applied to another case, another couple of cases which were decided in 2021. And then eventually we had another decision in 2023, which is the LF versus SCRL case. And then, interestingly, in the case that you mentioned at the beginning of the podcast, all these findings were somehow transposed onto the public sector.
So just to to clarify this, would it be correct to say that after the decision last November, the jurisprudence of the approach of the Luxembourg court is the following: that both private and public employees can actually ban religious symbols for some sort of very abstract requirement of neutrality without any further explanation? Is it correct?
Well, in a sense, so. Well, we can say so. What the court said in its last decision is that employers could prohibit the wearing of religious or ideological symbols, both with respect to customer-facing employees, but also with back office employees. So the court basically said that an entity could, if this entity wishes to do so, could enforce a policy of exclusive neutrality. And so from a terminological perspective, this is something brand new. The court in its previous judgments never mentioned and never used the adjective exclusive. So this is the first time ever. And the main difference here is that if in previous case law, the court said that the policy should be applied to what is strictly necessary. So generally, the policy could be applied only with respect to employees that are in contact with customers. Now this strictly necessity requirement, if so could put it, has been abandoned. And it gives broad discretion. So employers, be they public or private, now have broad discretion to, if they wish so, introduce an environment of exclusive neutrality. But another important aspect, I think, is that beyond that, the court also allowed to companies, public or private, who wish to do so, also to have religiously non-neutral environments. So environments that have religious diversity within them. So in a sense, the point is that the court is basically saying that employers have a kind of managerial discretion to decide on how to properly organize their environments according to their wishes. Now, this would make sense if we look at the case law of the CJU in the private sector. Well, we could say that somehow the court applies, if not directly, if not explicitly, somehow applies what American scholarship would call the business judgment rule, which means the court says that since the court is just a tribunal, it's not an entrepreneur, it will leave employers discretion to do and to organize their business according, depending on how they see it more fit and profitable, depending on their mission. But now the same managerial discretion has been transposed onto the public space, which seems to somehow create a mix of approaches. There's some things, preliminary things that I haven't clarified since at the beginning. The approach of the code of the CJU when it comes to human rights could be generally described as an economic approach, which mostly depends on the economic background of the CJU. The CJU is the tribunal that patrols EU law, and the EU since the very beginning was created mostly as an economic effort. Then the idea, of course, was to create a much more closer union, meaning that the union should have progressively incorporated economic but also political considerations. And so despite the union being created as an economic effort, well, it progressively developed its human rights pieces of legislation. So we have the Nice Treaty, for instance, that became legally binding in 2009. But still, this is just to say that this economic background strongly influenced, I would say that it strongly influenced the approach of the CJU, which generally reads human rights from an economic perspective. It is like if human rights were read through the lenses of the market. And this approach deeply influences the outcomes on human rights decisions generally and on freedom of religion in particular. So when it comes to religious employees in the workplace vis-a-vis for-profit employers, the court somehow will give much, much more weight to the discretion of employers, because it will consider the employers as the epitome somehow of the economic goals of the union, which is the freedom of circulation of people, capital, services, and goods. But what is interesting of this new case, of this new 2023 case, is that the court injected somehow its approach on religious freedom and business employer in the private sector onto the public sphere. But still, if we look at previous case law of the CJU on religious employees in the public sphere, and the outcomes were quite different. For instance, I'm thinking of some 2018 cases, the Egenberger and Aya cases, which were about disputes of employees within public sector, faith-based organizations, a church and a faith-based hospital. And in that case, the court, gave much more, decided in favor of the employees, because, it said, we should protect them. We should protect the religious freedom, because from an economic lens, protecting the religious freedom implies removing and reducing barriers to access to the marketplace. And so the court on that occasion said non-profit public entities could not impose too much severe occupational requirements onto employees, because too much severe requirements could actually limit their access to the market, and allowing employees to participate into the market is among our objectives.
So I basically actually took the same approach within the organizations which are faith-based, that their autonomy is kind of shrunk in that kind of context. Yeah, I find your analysis very, very interesting also in that perspective, that if you look at the human rights, then from the human rights, even from general human rights perspective, like putting an emphasis on business interests or business rights is deeply problematic. But I would like to push you on another matter. Neutral workspace is not necessarily neutral. It's one of my points I want to push you on. But related to that also, how do you see this desire or the moment of gender equality in that kind of context. Because if the businesses are seen also something that are need to be engaged with the public discussion or public debate, or more engaging or reflecting on those matters, then how the gender equality would be taken into account in the framework where businesses are given basically free hands to sanitize their workspace of any religious symbols for the sake of keeping the policy of neutrality within the company.
Yeah. Okay. Thank you, Merilin, for asking. Well, let me pick on your first consideration, that one concerning neutrality. Indeed, we are faced with a puzzle in here because, well, this policy, these policies that these companies introduced can be described as neutral, but this is just a very face value. They are somehow value laden in a sense. So they somehow reflect a particular cultural or even economic preference. So all this case law on these neutrality-based companies has generally been described as the epitome, as an example of discrimination from a cultural discrimination, of racism. So French and Belgian employers that are racists against Muslim employees. What I try to do in my research is to show how there are indeed some cultural elements that should be taken into account, but there are also some other economic aspects that I think have not been considered so far. So, for instance, if you consider the case of Bunyawi, which was one of the very first cases, well, actually both Bunyawi and in the Beta cases, one of the main problems is that some customers of these companies didn't want to be in contact with Muslim veiled employees. So this is necessary. This is definitely and quite evidently a racist instance expressed by these customers. But I think that what the employers did in this case was taking into account this customer's wish, which could be somehow imbued with racism, but they took it into account also on economic grounds. So if we do not, if we do not satisfy our customer wishes, we will basically lose a market. And so here is where I think there are some cultural and economic implications that should be taken into account. So cultural and economic implications that intersect. Similarly, we have intersections of discriminatory patterns at stake here that should be noted. These neutrality-based company cases generally and broadly pit against business freedom vis-a-vis religious freedom. But beyond religious freedom per se, there are some gender issues related and connected. Issues that the court itself decided not to take into account explicitly. So if we look at the last November case, the court said there might be some gender aspects that should be considered, but we could not say anything about that because gender falls outside the scope of Directive 2078. The directive covers discrimination on sexual identity, for instance, but the court considers sexual identity different from gender. There's another specific directive on gender equality, which is not Directive 2078. But still, the question was raised both in November by this new case, but also in previous instances. And the main problem is that, well, quite intuitively, if you prevent employees from accessing the workplace on religious grounds throughout a corporate policy of neutrality, this policy could, of course, adversely and negatively affect, say, Muslim employees, and they could be put at a comparative disadvantage than, say, Christian employees that wear a necklace that could be easily covered by a shirt or a uniform, for instance. But beyond that, if we take the case of the religious employees, the differential treatment can go beyond religion, because that employee might be wearing an hijab precisely because of her being a woman. And so, if you consider identities as make up by multiple levels, now we see how there's the religious and the gender level of identity that interact. And so this case, the gender case, has always been skewed and underestimated by the court in a very much more explicit way. It has been totally shunned, as the court said, as anticipated in the last case. It said, we are not going to take this. We are not competent to deal with this issue under the directive. But the thing and the problem is quite pivotal right now if we consider also the outcome of this new decision, which now says that the policy of neutrality will apply to all the environment. So not just with regard to customer facing, but also back office facing employees. So it will be broadly affecting all employees. And so the issue of intersectional discrimination could be exacerbated further. But this issue was not considered neither by the court, neither by the Advocate General, despite previous requests by other Advocate Generals themselves to raise this point. So in the 2023 case, Advocate General Medina considered this case. If you go through the opinion of this case, the Advocate General said we should take into account how, there might be intersectional discriminatory patterns here at stake, but still, the case was not taken into account. And since generally Advocate Generals reflects the union position, well, the court could decide whether or not to pick a particular opinion, but still, generally, the Advocate Generals represent the state. The court actually seemed not being interested to take into account this issue so far.
Do you, in your book, when you are looking at these matters, do you also, when you talk about the religious employers and the employment relationships between individuals and religious employers, do you also differentiate between the different religious employers? Because there can be churches themselves, let's say, or the main organizations, whether churches or other organizations, or they can be sort of affiliated or attached to religious organizations, juridical persons like publishing houses and etc. Do you differentiate, and do you see also any difference in the approaches between different courts to these different categories of religious employers?
Well, actually, the scope of the book was to differentiate between these employers. So the idea is, well, of course, you can have churches that will now more and more rely on secular entities somehow connected to the church itself to carry out non-religious commercial activities that are, however, necessary for them to survive. This is due to, well, some changing landscapes. Nowadays, churches could not simply rely on oblations, donations, and so forth. They need somehow to rely on a kind of commercial activities. And so they need to set up some proper secular institutions that will mostly have non-religious purposes, but still they will act in a deeply related way to the mission, to the spiritual mission of the church. So I make this as a premise, and I considered this kind of employers as one thing. But then with this as a premise, what I wanted to do in the book was consider another trend. So the case of freestanding secular entities, well, which are from a legal point of view, secular, established, for instance, as for-profit employers who, however, use religion and imbue religion within the corporate governance. So now they will not be using and they will not carry out activities that are directly related to a church, because they are not directly affiliated to a particular church. But as I said, they might be freestanding employers who are simply believers and want to use religion and see it as part and parcel of their business. So this is something that for European readers or listeners, I think might be quite weird. It quite might strange, but in the book I try to explain how this is not that strange if you move to the other side of the Atlantic. So if you look at the United States, where it would be quite common to have for-profit employers, not necessarily affiliated to a church, claiming to be business in the name of God, and somehow asking the same treatment that the law generally would provide to churches. And so we see in the United States, we saw a kind of blurring line between the non-profit and the profit sector, actually. And this happened in 2014 with the very first case of a for-profit company claiming religious exemptions in a church-like fashion, as I could put it, the Hobby Lobby case, which has been grabbing headlines for a very long time.
Matteo, what about the European Court of Human Rights case law in this context? How does this court contribute to the judicial dialogue on FoRB and employment?
When it comes to ECtHR case law, the margin of appreciation of states is narrowed down, but the court still deals with religious freedom and with religious freedom conflicts as proper human rights related conflicts. So the court will consider, say, the religious freedom of a church as a conventional human right as opposed to other human rights. It will try to balance them, but in the balancing exercise, it will give much more weight to the ecclesiastical rules of a church rather than other elements. In the United States, what is interesting to see is that this conflict seems to be framed not even as human rights issues, but as proper jurisdictional conflicts, if so I could put it. So it is like if the court says, when it comes to, issues concerning the dismissal of an employee from a school, from a church entity, so far, our approach will be totally hands-off, because we will not deal with the rules of a church which has a jurisdictional proper autonomy. So this is, I think, the interesting nuance that we are seeing so far. The ministerial exception has been crafted as a particular interpretation of the First Amendment to the United States Constitution. As I said, the literature would say that this ministerial exception somehow reflects the introduction of a principle of church and state separation, which is not included and is never mentioned within the United States Constitution. And so conservatives in the United States will generally interpret the combined effect of the First Amendment as introducing as a proper principle of freedom of the church. So as an entity that from a jurisdictional point of view should be able to organize itself without interference from another jurisdiction, which is the civil one of the state. So just to wrap up, we will have basically some parallelisms between the ECtHR and the United States in terms of case law and their trends, with the only difference on my own perspective on this very, very small nuance. So the ECtHR will still applies and still deals with church autonomy as a proper human right, but it narrowed down the margin of appreciation of states. The United States narrowed down the margin of appreciation of states because it considered these issues more as conflicts between jurisdictions rather than more conflicts between human rights per se. And then we have the CJU, the CJU, which narrowed down the autonomy rights of churches by introducing the economic element. So employers who, church employers, which impose too severe occupational requirements onto employees, will actually prevent and limit the access of employees from in the market. And therefore they will, which is something that in the long run could disrupt the objective of a social market economy, which should be having very dynamic workplaces characterized by diversity, the diverse contributions of employees. So this is pretty much, I think, the different approaches in church autonomy disputes between these three jurisdictions.
Can I just have one additional question to you in that respect? Do you feel then that all these trends in these different courts, these two courts in Europe, one the European Union Court of Justice, ECtHR Court, the court which deals with human rights issues, and then the Supreme Court of US, which is a domestic court, do all these differences and trends in the approach actually stem from the fact that we are dealing with very, very different courts because of the nature? Because the EU court is something which is, dealing with EU and EU law and application of that, and the initiation of the EU was initiated because of economic reasons and economic cooperation initially. European Court of Human Rights was specifically established to deal with human rights in Council of Europe states. It's a regional human rights court, and that's why it's specificity. And the US Supreme Court is a domestic court of one big state where, but of course the approaches, they may have similarities and differences, but the substance of the courts themselves may indicate why or which way these courts are going.
Yeah, definitely. I totally agree with you. Okay, yeah, the main difference inherently depends on the different philosophies, so I could put it, underlying the codes, as you noted. So look at the European Court of Human Rights. Okay, it's the tribunal that patrols the Council of Europe, and the Council of Europe was established precisely to create new legislation protecting individuals. So the main goal was somehow to avoid gross human rights violations that happened during World War II, and there was also the concern of communist subversion. So we were entering the Cold War era. So the Council of Europe deals with human rights as human rights per se, precisely because of that reason. So the approach of the court is generally aimed at progressively bringing much more higher standards in terms of democracy and the rule of law. So the European Court of Human Rights, because of this background, will generally consider human rights as ends in themselves, which is something different when we move to the European Union, which seems to be considering human rights as means to an end, not an end in themselves. So human rights could be tools that in the long run could also promote the social integration of the market, and social integration of markets and free trade market principles could have positive trickle-down effects on the individual sphere. So somehow the approach of the European Union somehow maps with the approach, the economic approach that I mentioned at the very introduction of this podcast. This is the approach will be somehow will mostly and favor human rights only if these human rights will serve the needs of the market. It is what Marco Ventura would call a competitive approach. So the human rights that win the most at the CJU are those that are much more linked to the economic goals of the market, freedom of circulation of people, capital, services, and goods. Just to give you an example that could make clarity. If we go back to the 70s, and particularly 1974, the European Code of the European Community, it was not yet European Code of the European Union, but European Code of the European Community. In 1974, the code had to deal and dealt with its very first religious freedom case. Now, this case was about a Dutch member of the Church of Scientology who wanted to move to the United Kingdom to take work at the British branch of the Church of Scientology. But this Dutch national was prevented access in the United Kingdom because of the government and the Home Office considering Scientology as socially harmful, as a cult, as a sect, which could have posed problems in terms of public order.
Here, Matteo is discussing the case E11 versus Home Office considered by the court in 1974.
Now, the case was brought to the CJU, and for the first time, the Court of Justice accepted and declared itself to be competent on religious freedom, because this religious freedom issue was deeply linked to the freedom of movement of this person who wanted to move, indeed, from the Netherlands to the UK to take a job, to take employment in a church, in the Church of Scientology. Now, on the end of the day, the Court of Justice decided against the employee, but this for other reasons, because it posed a much broader focus on public policy, public order matters. But still, what is relevant to note is that with this first case, for the first time, the court said, despite my background being mostly economic, I understand and I declare myself competent on this religious freedom case because it has some economic related implications, in this case concerning the freedom of movement of individuals. And this somehow was the harbinger or the forerunner of the future approach of the Court of Justice on human rights. And the court itself has developed its own human rights pieces of legislation. So we have the nice charter, the Charter of the Fundamental Rights of the European Union, which became binding in 2009. So the European Union has some human rights standards. But the point is, how does the Union interpret these standards? And the interpretation generally is mostly influenced by its economic background. So this somehow explains the two counterposed approaches. I mean, this could be used to explain the counterposed approaches of the CJU in church employment matters on the one hand, and secular employment matters on the other hand. So when it comes to church employment, from an economic perspective, the court gave particular value to the right of employees to access the workplace under Directive 2078 and under the NICE Treaty, because this was seen as necessary to promote a socially integrated market environment. And so it put a brake somehow on the autonomy rights of the employer, striking an economic approach to religious freedom. When it comes to disputes in the secular employment, the organizational autonomy of employers is maximized. So we have somehow the Court of Justice narrows down the autonomy rights of church employers, focusing on their non-profit nature and giving much more strength to the interests of employees accessing the labor market. But in contrast, the CJU will strengthen and broaden the margin of autonomy of for-profit companies, precisely because it would put a stress and an accent on their profit nature, which is considered as being very, very deep and strictly related to the economic objectives on the market. And in these cases, by strengthening the autonomy rights of business employer, the result would be a diminished religious freedom protection for employees. And this is what we have been witnessing since 2017 to present, starting with the G4S solution case and Bunyewi, and then in 2021 with Vovk and the Mueller case, and then in 2023 with LF versus SCRL case. And then we had more recently in November, the case of commandants, which is even much more interesting because, well, that case was about a public environment, a municipality. So, I mean, in my view, this conflict was quite similar to the conflicts that the court dealt with in 2018 with public religious entities. So if the court had to follow this 2018 precedent, it should have narrowed down the autonomy rights of the employer, but it didn't. And actually, I have no explanation to that. It might show how the CJU is becoming schizophrenic somehow. So what the court did in this new case was actually using its economic related findings on religious freedom that it progressively carved out from Ashbita, Bunyewi, LF, Wab and Mueller, and LF versus CRR. So transposing these economic related findings on neutrality-based companies into the public sphere, while at the same time stressing in particular the margin of discretion of states in an ECtHR style. So the court said, the CJU said, and focused on the margin of appreciation of states, saying that these public entities, being representatives of the state, have a margin of discretion to autonomously organize themselves. So somehow the court in this case was stressing, putting an accent on the margin of appreciation like it usually did, the ECtHR. But to reach this conclusion, so the stress on the margin of appreciation of states, the court used elements from its economic related religious freedom findings. So it is somehow if the CJU mixed together its economic convention approach with the ECtHR margin of appreciation focused approach. I don't know if this makes sense to you, but in my view, this new case seems to show us how there is an intersection between approaches in the court judgment.
And this is all for today. We thank Matteo Corsalini for joining us and sharing his insights and enlightening us on the complexity behind freedom of religion and belief and employment, and on really difficult judicial dialogue behind these issues and cases. It's not really a dialogue, it's probably a polyologue, as we have three courts. This is Dmytro, Vovk, and Merilin Kiviorg for the FoRB Podcast, part of the Talk About Law and Religion blog of the International Center for Law and Religion Studies. I should also say that the opinions expressed in this podcast do not necessarily represent the opinions of the faculty or staff of the International Center for Law and Religion Studies or the J. Reuben Clark Law School, nor do they necessarily reflect the views of Brigham Young University or its sponsoring church. Tune into additional episodes on talkabout.iclrs.org or on Spotify and YouTube.